Yeah, so tonight we would like to discuss membership of companies. That is a part E of Companies Act 2019 at 992. So first and foremost, we would like to understand when we say membership of the company, how is it constituted? How is it composed? Who constitute like the members of the company, and what are their rights? Are there any liabilities? And then where the company, for example, should cease to have like a member, what happens to the affairs of the company, and so on and so forth. So in accordance with the approach which we use, that we discuss the law itself, we are going to proceed from section 33, and then we analyze the relevant law. So the reader can take section 33(1) for us.
Sir, please, my hand is up.
Yes, okay. Yes, go ahead.
Yes, sir. Per my understanding about the limited liability companies, I understand that their members are liabilities are limited to the amount paid, especially the shares and guarantees. Now, my question is: sometimes you see that some company limited companies will enter into a contract acting by its members. And you see that sometimes when they default, maybe if it is a loan, they default, and then the aggrieved party goes to court. Sometimes you see that on the rate they endorse the company, they sue the company, and then sometimes pay the manager. Instead of separating the manager as a separate either defendant, no, they don't do that. They just box if it is AK Company Limited, pay the managing director. So in that instant, is it right? And if it is right, and you get judgment, can you go for the personal property of the manager because the manager name is mentioned on the rate?
Okay, thank you very much. You notice that your questions are answered by the decisions in Solomon and also Moko and Kuma. We know that the company has a separate legal personality, and one of the consequences of such a legal principle is that the company can sue and be sued. And for that matter, if you are suing the company, it's a company that you sue. You don't say, for example, SY Limited per NSO Sudapa. No, it doesn't work that way. Even if I am the managing director, you don't have to say SY Limited per NS or whatever. Rather, you just sue SY Limited, just like that. And you notice that in the case of Moko versus Kuma, if you've read the case, which you are supposed to have read, that issue actually came up, and the court agreed that it was wrong to have actually sued the managing director as part of the suit. That's why the fact that the managing director is the one who did the transaction, if you like, on behalf of the company. It was actually the company which was acting. For that matter, if you want to sue the company, you sue the company itself. You don't have to do any pay. Now that practice, which has been going on in some of our courts, is a bad practice. And in fact, even if you see some lawyers who indulge in that, it's just symptomatic of inadequate or inappropriate understanding of company law. But that is quite wrong. just sue the company. You don't do any pay, so no. So it doesn't really work like that. If you are talking about like the incorporated trust, that is, they have what call like the board of trustees, and if you look at the relevant enactment, then it may say that if you want to sue that trust, you probably sue like the incorporated trustees, but that one is a different ball game. But if you are talking about the incorporated company simpliciter, if you want to sue it, you have to sue it itself, and you don't need to add the pay. Okay, and again, if you get a judgment, you apply the judgment against the company itself. You don't apply it against the assets of the directors or managing director or shareholders, as it were. Now, the only time, okay, especially those of you in the banking and financial industry, you probably be conversant with this practice, where maybe a company comes to contract a facility, and you get the maybe a director or a member of the company, probably the majority shareholder or anything like that, providing a guarantee, right? Providing a guarantee, that is guaranteeing that the company will pay. And should the company default, the guarantor is prepared to bear the responsibility. Now, where that is the case, if you sue, you are going to sue the company and the guarantor jointly and severally. So what is happening is that you are not undermining the company law principle called the separate legal personality. No, because here we have two transactions at stake. We have the original transaction between you, the plaintiff, and the company, right, in which the company has defaulted. And there is a related transaction, that is the contract of guarantee. The guarantor guaranteed the repayment, and the company has actually not paid, and the guarantor has also failed to pay. So you are suing the company jointly and then severally with the guarantor. So that is maybe the exception to the rule that we just see only the company. But here, you notice we have two defendants. The company has one defendant and the guarantor has another defendant. And it's not the case that you are just doing like the company pay the guarantor. No, it doesn't work that way. I don't know if that helped you to understand.
Very clear.
Okay, so we come to membership of companies, and I wanted one of you to read section 33(1). I haven't heard the lady's voice tonight. Is there any lady here? The lady should read it. Your class is becoming male oriented class.
Yeah. They're around.
Yeah, so one of the ladies should take it.
Okay.
I'll read.
Go ahead, please.
Yes.
Okay, sir. So members of a company, the subscribers to the documents for the incorporation of a company are members of the company. Sir, please, should I read?
Yes, you haven't finished.
Members of a company. The subscribers of the documents for the incorporation of a company are members of the company upon Okay, members of the company, section 33, subsection 1. The subscribers of the documents for the incorporation of a company are members of the company, and upon incorporation shall be entered as members in the register of members referred to in section 35. Subsection 2, any person who agrees with the company to become a member of the company and whose name is entered in the register of members is a member of the company.
Good. So to start with, we are trying to know who is a member of a company. And the law is quite clear that we have first and foremost two main categories. First, we have subscribers. Subscribers. If you're a subscriber to the documents, that is, if you say subscriber, we mean those who append their signature to the documents, or those whose names are put in the documents applying for incorporation of the company. So they are to be entered in the register of members as members by reason of the fact that they are subscribed to the incorporation document. And then the other category refers to anybody who agrees with the company to become a member. So after incorporation, anybody who agrees to become a member and the person's name is entered in the register of members of the company is a member. Now, let's pay attention to this provision well, because it has given rise to unnecessary controversy in the case of Adeshiman Gardens against Asibe, which we have mentioned in passing before. Adeshiman Gardens, let me put it here. Adeshiman Gardens. Gardens against Asibe. Let me get a citation for you. Okay, so, and you know, there has been this dispute as to whether a person who has not paid for his shares fully can be considered a member or not. And that is why I want us to pay attention to the wording of the law. The law never said that where you have fully paid for your shares. All that section 33(1) and 2 are telling us is that first, you were a member. If you were to start with, if you were, for example, what do you call like a subscriber, or if you were not a subscriber, the company has come into existence and you agree to become a member and your name is entered in the register of members, then to all intent and purposes, you are a member of the company. So we have to pay attention to that. So please look at the Adeshiman Gardens against Asibe, 2003-2004 Supreme Court of Ghana Law Report, 1016. Very interesting case. And for the present purpose, in relation to Section 33(1) and 2, it clarifies the issue that it is quite unnecessary for anyone to insist that if you haven't fully paid for your shares, then you are not a member of the company. So if you read the case, you will notice that what really happened was that the appellants and two other persons, including the respondent, incorporated the company limited by shares. You know, Adeshiman Gardens, right? It used to be very popular in Kumasi with a million shares and was subscribed to the regulations of the company. So the regulations, as we were told the last class, used to be the name of the constitution. But now we've abandoned regulation and simply say just like the Constitution. Now, there arose differences between the appellants and the respondents in the management of the company. Consequently, the lawyers of the company wrote to the respondent, informing him that since he had not paid for his shares, he was only a nominal shareholder of the company. So underline, nominal shareholder of the company. That's what the lawyers wrote to the respondent. The respondent was given 14 days in the letter. 14 days ultimatum to pay for the unpaid shares. Otherwise, his shares will be offered to a different person. And another letter was also written to the respondent, and the appellants in that letter informed the respondent that the net value of the company was a certain amount. Those days, the old currency, 237 million cedis, not the current Ghana cedi, but the old one. And therefore, in order to become a fully fledged shareholder, he had to pay a fraction of that, which was a little over 47 million old Ghana cedis. And they also filed an application in the Registrar General's department, notifying the registry of change of directors and appointment of 5 new directors. Now, when the respondent got these letters and became apprised of these developments, the respondent brought an action or case in court against the company, seeking a declaration that he was a fully paid up member shareholder and a director of the company. Now, when the matter came before the trial high court judge, he dismissed the case on the basis that even though the respondent was a subscriber to the regulation, that is the constitution of the company, he had failed to produce sufficient evidence that he had paid for the shares. Now, certainly, the respondent was dissatisfied with this decision and decided to appeal the decision to the Court of Appeal. And when the matter came to the Court of Appeal by majority, no is always 3, so by 2 to 1, the Court of Appeal held that the respondent was a shareholder and a member of the company, and that the demand made on him by the company to pay the stated amount for a share was wrong. The appellants, that is the company, and other people were also dissatisfied and decided to appeal the decision of the Court of Appeal to the Supreme Court. And the Supreme Court dismissed the appeal and made a holding under Section 30 of the Repeal Companies Act 1963 at 179, which had been replaced by Section 33 of Companies Act 2019, Act 992, and held that there are 2 kinds of members of a company. Those who become members at the inception of the company by subscribing to its regulations, and those who, after the company came into existence, agreed to become members. So these were the 2, of course. And what the court was saying was nothing new, because that is what is stated in the law. And even in the reenacted Section 33 of Act 992, we see that as we read. So the Supreme Court in Adeshiman Gardens against Asibe went on to hold that the membership of a subscriber was by a legal prescription, and in the absence of a valid forfeiture, was not predicated on full or partial payment of the consideration for the shares taken. And consequently, since the respondent was a subscriber to the regulation of the company, he, pursuant to section 30 of Act 179, became a member of the company right from the date of its incorporation, holding whatever number of shares, that's in this case 200,000 shares, as indicated against his name in the regulation. So the court was saying that, yes, if you are a member by reason of having been a subscriber to the incorporation application documents, then your membership is by legal prescription. It is the law which has conferred membership on you by reason of the fact that you're a subscriber and your name has been entered in what? In the register of members. And for that matter, your membership was not predicated upon whether you had fully paid up for your shares or you've not fully paid up for your shares. And the court said that as whether a person will lose his membership or not, how to be brought within the provisions of the law, and not just anybody saying that you haven't paid and then you are going to lose your membership. And so very soon you notice that if you behave in a way which will bring you within the circumstances stated in maybe section 33, subsection 4, 5, and 6, you will lose your membership. But outside that, the Supreme Court is of the view that if you were a member by being a subscriber, you don't just lose your membership just because somebody says that you have not fully paid up for your shares, and so on and so forth. So let us keep that in mind. And just before we move on to section 33, subsection 3, another thing I want you to pay attention to is that the Supreme Court, the law, the Companies Act is not simply saying that just because you're a subscriber, you're a member, or just because you've agreed to become a member, you're a member. No, there is another requirement. Your name must be entered in the register of members. Because the register of members is actually an important evidence of whether you're a member or not. Your name, just like, for example, if you say you're a lawyer in Ghana, and we go to look at the roll of lawyers, the roll of lawyers refers to the register of lawyers. Your name is not located anywhere. Then you are not a lawyer. And that is why every lawyer, on the day that you become a lawyer, we are due to the number of lawyers. So there's a number that you get. That is the number you have on the roll. So if you're a member of Company 2, your name must be entered in the register of what? Of members. So let us keep that in mind. So please, everybody should read Adeshiman against Asibe. Adeshiman against Asibe. Let's look at 33, subsection 3.
See, should I read, sir?
Yes, but I think just before you read that, I think that I should draw your attention to two other cases, especially 33.2. You know, 33.2 told us about membership by what? Agreement to the company. That is, the company has come into existence, and you've agreed to become a member of the company. So for that, I would like us to look at the old case of In Re West Coast Dyeing Industry Limited. That is Adams and Tando. A very interesting case. We meet it again when we're discussing the directors. Let me put it here for you. In Re West Coast Dyeing Industry. Limited. Adams Stand up. Give you the citation. (1984). Ghana Law Reports. 84, 86. Ghana Law Reports. Page 589. And then also let's look at the opinion of Justice Atepa in Aussie Air. Aussie Air to remit it again later on. If you read it now, Aussie Air Limited versus DACO. (2005). 2006. Supreme Court of Ghana Law Reports 1057. Yeah, so please look at the Adams and Tando and then Aussie Air Limited against DACO in further explication of membership by agreement with the company. Okay, so let's continue to look at subsection 3. Subsection 3. Is the reader there?
Yes,
okay.
Please, I'm here.
Yeah, go ahead.
Subsection 3. A member has the rights, duties, and liabilities that are by this act and where applicable by the registered constitution of the company conferred and imposed on the members.
Okay.
Subsection 4.
No, I think before we discuss, I see that Nana Kweku Seni Brimpong has raised his hand. So please, let's hear you.
Hello, sir.
Yes. Yes, yeah, go ahead.
So you made mention that if you have their own constitution and incorporate anything that they would want members to abide by or would want the registrar to have a notice of, that may act particular company. So if a company in its constitution wants someone to pay his shares in full before he becomes a full member, if it's against or if that particular provision goes contrary to section 33, will that provision be struck out? That is my question.
Okay, so the thing to remember is that where a company is adopting a constitution, is at liberty to make provision for anything, so long as what the company is providing for are not against mandatory provisions of the Companies Act or any other enactment. So that is the first point that we have to actually remember. So you come to subscribers, for example. If you look at section 14, no, section 13, when we're discussing application of an application for incorporation, you notice we came across the subscribers that if you look at the 13 subsection 2 paragraph H, for example, the following particulars of each subscriber for a proposed company with shares. Okay, then that is stated over there. Then look at section 13.3, that the application shall be signed by the subscriber or each subscriber, if more than one, for shares of the company by writing opposite the name of the subscriber, the number of shares the subscriber takes and the cash price payable for the shares, and the subscriber shall take at least one share. So what the law makes mandatory is that every subscriber must have at least one share. So long as a company has satisfied that legal requirement, there is nothing wrong for the company to say that apart from the first share which the subscriber must have, all the other shares must be fully paid for. Otherwise, those other shares will not count towards the person's right. There's nothing wrong with that. So the bottom line is that what the company is providing for in its constitution must not be in contravention of the mandatory provisions of the Companies Act 2019 or any other enactment. If that is observed, then the company is at liberty to make additional provision. And I'm sure that when you were discussing what do you call it, the content of the constitution of the company, you came across that, especially if you look at section 29, subsection 4, right? Section 29, subsection 4 is to the effect that, and I quote, the registered constitution of a company shall be void to the extent that it contravenes or is inconsistent with this act. So section 29, subsection 4 of Companies Act is providing a substantive limitation, right? What do you call it? Like the substantive constitutionalism, that if the company's constitution is inconsistent with the Act 992, then to the extent of the inconsistency, it is void. Yeah, so that is the what we will say. I don't know if that assists you.
Yes, sir, I'm okay.
Okay, so let's
Thank
come
you,
back to section 33, subsection 3, referring us to the rights, duties, and liabilities which go with membership. Membership is a legal status, and every legal status has attended upon it certain rights or privileges, and of course, certain duties. So legal status goes with rights and what? Liabilities. So being a member of a company is no different. And if you wanted to know the bundle of rights, duties, and liabilities applicable to the company, we have to look at the Act, the Companies Act. So the Companies Act has a compendium of rights, right? For example, that if you're a member, you come to know that you're entitled to attend meetings, whereas you're a member of a company limited by shares, dividends are declared, you're entitled to your dividends, and so on and so forth. All these are rights which are provided for by the Companies Act 2019 Act 992. But in addition to that, it is permissible if the company has a registered constitution to confer some additional rights which are not even in the Act, or to impose additional duties and liabilities. So that is what is remembered by 33.3. But where the company is a company registered with shares, then it is mandatory for each member to have a share, at least one share. Of course, that is by definition. If you're a member of a company limited by shares and you don't have a share, that is why when I refer you to section 13, that is the provisions on application for incorporation. It was quite explicit that if you are a subscriber to the incorporation application for, in relation to a company being registered with shares, then you must have at least one share. So if you're a subscriber, you must have, if you are not going to have anything at all, you have even one share. And that is why 33.4 is also reiterating that if you are a member in a company with shares, then you must have at least one share. And just for avoidance of doubt, our lawyers will say that as abundantia cautela, section 33, subsection 5 is quite clear that a holder of a share is a member of the company. In other words, where you have a share, that is an evidence of what? Membership, or that makes you a member of the company. But you see, the difficulty with having 33.5, and I want us to be thinking as the students of the law, having 33.5 says that a holder of a share is a member of the company. But if you go to 33.1 and 2, if you look at 33.1, you notice that apart from, let's say, being a subscriber, there's additional requirement. You see that conjunction or the conjunctive word, and upon incorporation shall be entered as members in the register, right? Now, if you look at 33.2, the person who agrees with the company to become a member, we have a conjunctive word there, and whose name is entered in the register of members is a member of the company. So one may ask the question, does it mean that section 33, subsection 5 is detracting from the requirement of having the name of a member in the register of members, as whether the membership came by reason of subscription or by agreement with the company? Well, my answer is that no. Section 33, subsection 5 is in no way undermining the requirement for having the name of a member entered in the register of members. Because you notice that when it comes to issue of shares, when we are discussing shares, it is part of the requirement that where shares are issued, then the holder of the shares should have his or her name entered in the register of members, and then his number of shares written against his or her name, and so on. So section 33.5 should not be taken in isolation, despite the fact that on the face of it, it may appear very simplistic, and it may create impression that so long as you are a holder of a share, then there's no need for your name to be entered in the register of members, and that suffices to establish your membership. And I am submitting to you that that is not really the case, because if you look at the rules in relation to issue of shares, you will notice that having the name of the holder of the shares entered in the register of members is part of the process. So there's no way that you be a holder of share and then your name is not entered in the register of members. Yeah, Ken, your hand is up. You have the floor.
Yes, sir, but I think my question has been answered by your last statement. I was coming to ask, is there a way that you can have a share without your name being entered in the register? But your last statement actually answered that there's no way you could be a shareholder without your name in the book or in the register.
Yeah,
Thank you.
Absolutely. Yes. Okay, so let's move on to subsection.
Sir, I have some contribution on the 33, 5, 4, and then 5.
Okay.
If you read them together, it means that apart from being a subscriber, as was stated in Adesiman, is not enough. You must have at least one share.
Okay.
And so I'm asking my question that is Adesiman still a good law today?
Yeah, Adesiman is a good law. In any case, Adesiman Gardens against Asibe was only trying to amplify the existing statutory provisions. And in the repeal at 179, the relevant provision was added in section 30. And section 30 has substantially been reignited as section 33. So, and if you look at the other provision in relation to subscription, that is like subscribing to the regulation then, is not different from what we have here. So all that the Supreme Court sought to do was that it is wrong for you to say that someone who was a subscriber to the regulation or subscriber to the constitution of the company, having acquired his membership of the company by legal prescription, as the provision says, for you to insist that insofar as he or she has not fully paid down for all the shares which he took upon subscribing to the regulation of the constitution of the company, does not have a full membership. The court said that is wrong. And I think that is a proper understanding of the legal provisions. So Adesiman Gardens against Asibe is not really a bad law in that respect. Okay, the question.
Yes, sir. Yes, sir.
All right. So
yes,
let's take, yes.
Shares are traded at the stock exchange. So those who buy the shares from the stock exchange, how would their names be immediately entered in the register?
Okay.
And that become a member of the company.
Okay, good. So later on, when we are discussing shares, you notice that there is something we call the Central Security Depository Act, which has created the regime for dematerialization of share certificates, and an exception is created. So if you look at the section 56(4) later on, you notice that where a company is actually subject to the dematerialized share regime under the Central Security Depository Act, just like the companies whose shares are traded on the stock exchange. You don't need to do some of the things which non-listed companies will have to do with respect to their shares. And they usually use digits, right? So shares are signified by, if you like, numbers or certain code and so on. Yeah, so an exception is created. An exception is created, but here we are talking about unlisted companies or non-listed companies which are operating outside the stock exchange. And of course, greater majority of companies are not on stock exchange. In Ghana, for example, without any prior empirical investigation, I can guess confidently that we have at least 90% of incorporated companies, not on the Ghana Stock Exchange, as it were. So let's take section 33.6.
So I want to also add something to what Charles has said.
Okay.
In relation to the additional case, Charles was asking whether it is still a relevant case.
Right.
I think that is why when we come to the company limited by shares, the definition is telling us that the type of company is telling us that those who have their shares unpaid, in case of liquidation, those people will be held responsible to come and pay up their portion of the shares they didn't pay.
Unpaid,
so for the High Court to make such a decision, I thought, in my opinion, too, was an erroneous decision. If not, if the company was to be or to be a wind up, then you can't compel him to come and pay the unpaid shares. So to me, it's still a relevant and good precedent for our judicial system.
All right, thank you. So section 33 says, our reader, she's sleeping. Okay, anybody?
Yes, sir. Section 33.6.
Yes.
Members of a company with
Membership.
shares. Membership of a company with shares continues until A valid transfer of the shares held by the member is registered by the company. B, the shares are transmitted by operation of law to another person or forfeited for non-payment of costs. Or C, the member of the company dies.
Okay, so in Adesheman Gardens against Asibe, the Supreme Court alluded to equivalent provision of 33.6 in the repeal at 179 and said that once you have your membership by legal prescription, as in subscription to the regulations or through agreement with the company, then your membership will remain in force until any of the stated events or circumstances have occurred. And these are that your membership will come to an end where you have validly transferred your shares to another person. So once you transfer your shares to another person, you go to the company and take the appropriate form, which is used to notify the company about transfer of shares. Then the company will now enter particulars of the new holder, the transferee, or the new holder of the shares into its records. And the previous holder or the transferor will cease to be a member of the company because we're dealing with the company with shares, and being a member of the company with shares must have at least one share. So where you have transferred all, right? You transferred all of the shares that you hold, then you automatically cease to be a member. But let me add that where you don't transfer the totality of the shares that you hold in the company, but you transfer only some and leave still hold on to even one, your membership will not cease. You still remain a member. And again, your membership may also come to an end where shares are transmitted by operation of law to another person. So when we say by operation of law to another person, somebody has put something down. Okay, right. Somebody said, can we explain the non-payment of all? Right, we explained that. Don't worry. So where your shares are transmitted by operation of law, that is to say that it is law which in certain circumstances is saying that your shares should be taken over by another person. And there are a number of situations in which we can say that shares are transmitted by operation of law. For example, where your shares can probably even be attached, or the court can make certain orders against you, or maybe when it comes to matrimonial proceedings and so on, and the courts want to, for example, make orders as part of property settlement and so on. You could, for example, have shares taken over and given to another person and so on. Or you go to, let's jump to section 102, right? Let's jump to section 102 to, because I am using like the screen, I'm not going to move my my screen because it's difficult to come back and the screen may go frozen. So if the reader can jump to section 102 and read section 102 one for us before we move on. Yes, please. 102 is at page 84.
102. The title, transmission of shares or debentures by operation of law.
Yeah, so please pay attention.
102.
Transmission of shares by operation of law. Yes, go ahead.
102.1. In the case of the death of a shareholder or debenture holder, the survivor or survivors, where the deceased was a joint holder, and the legal personal representative of the deceased, where the deceased was a sole holder, or last survivor of joint holders, shall be the only person recognized by the company as shareholders or debenture holders.
Okay.
2,
yeah, go ahead.
A person on whom the ownership of a share or debenture devolves by reason of that person being the legal personal representative, receiver, or trustee in bankruptcy of the holder, or by operation of law, may, on the evidence being produced that the company may properly require, be registered personally as the holder of the share or debenture, or transfer the same to any other person, and the transfer shall be as valid as if that person had been registered as a holder at the time of execution of the transfer.
Okay, good. Yeah, so we are being told that your membership of a company registered with shares could come to an end by operation of law, and we are giving instances where you join shareholder and you die, the other person is surviving. So the one who has died, that person's membership will have actually devolved to the survivor. Or where you die and you are the shareholder, someone has gone for letters of administration or probate, become like the personal representative, then on basis of that, you will actually, because I mean you are dead and then this person become your personal representative, operation of law, he will have the share vested in him until it is vested in any other person who is supposed to have it. Or where you are subject matter of bankruptcy proceeding, right? Let's suppose that you are not able to pay your debts and liabilities, and you file for protection under the Personal Insolvency Act, as it were, and you are declared bankrupt. And as part of the arrangement, the court appoints someone to take charge of your affairs and manage your affairs, what you call like the trustee in bankruptcy. Or in that case, whatever shares that you have will be transmitted from you to that person. And this is by operation of what? Of law. So let us keep that in mind. So read section 33, subsection 6 in conjunction with section 102 of Act 992. Now, another way by which you may also lose your membership, or membership may come to an end. I hope you're paying attention, because this can be an examination question as well. All the things you are learning, they are very interesting things. And if you want to examine students, there are a lot of things that you can do or examine. Yeah, so you may also lose your membership by reason of forfeiture for non-payment of course. So when we say non-payment of course, what do we mean? Now, we have made the point that where shares are issued to a person, the person is supposed to pay money or supposed to give consideration for the shares. However, the company may agree that the shareholder should not pay for the full value of the shares immediately, and only a portion or a fraction of the value for the shares which have been issued to the shareholder may have to be paid upfront, and the remaining balance paid later on. In that case, the company reserves the right to request or demand the shareholder at a later date, as agreed under the terms of the issue, to ask the shareholder to come and make payment. Now, where the company asks the shareholder to come and make payment, the technical language you use is that a call has been made on the shareholder. So a call has been made on you to come and pay your unpaid liability in respect of the shares. Now, where a valid call has been made on you and you have ignored it, you have failed to honor it, then your shares may be canceled. And when it is canceled by reason of non-payment following a valid call made on you, we say that your share has been forfeited. So forfeiture, if you like, your shares will be taken over. You forfeit it. So the company will let you lose the shares which were given to you because you have failed to pay for the unpaid value. And by reason of that, you cease to be a member. And then we are also told that where a member of the company dies, membership will also come to an end. Of course, C does not stand alone. C is in conjunction with the operation of law, because if the member dies, his share will devolve by operation of law to the personal representative until the personal representative who will be given the letter of administration or the probate, for example, execute the vesting assent and vest the shares in the beneficiaries of the estate, as it were. Let's look at how membership comes to an end in respect of company limited by guarantee. That is, company which does not have shares, but the members have made the undertaking. If you look at 33.7, membership of company limited by guarantee continues until the member dies or validly retires or is excluded from membership. So you notice that we have a whole world of difference between how membership of a company with shares ceases and how membership of company limited by guarantee ceases. So in the case of company limited by guarantee, death of the member will mean that his membership has come to an end, or where the member validly retires. That is to say that if under the constitution of the company limited by guarantee, you can, for example, excuse yourself from the company and then you retire in accordance with the agreed principles, your membership will come to an end. Or if you violate the constitution of the company and they trigger the relevant provisions to fire you or exclude you from the company, then your membership will also come to an end. Now let us quickly discuss the right of member to attend and vote at general meeting. Section 34, read it for us.
Section 34, the right of member to attend and vote at general meetings. 1. Subject to subsection 2 and section 52, a member has the right to attend a general meeting of the company and to speak and vote on resolution before the meeting. 2. Despite subsection 1, a registered constitution of a company may provide that a member is not entitled to attend and vote at a general meeting unless the cost or any other sums of money presently payable by that member in respect of shares in the company have been paid.
Okay. Now, as a member of the company, as a general rule, in terms of section 34, you have the right to attend general meetings, be it annual general meeting or extraordinary general meeting. And not only to attend, you also have the right of audience. You have the right to speak to any of the issues before the meeting, and also to cast a vote should it become necessary to pass a resolution during the meeting. So these are some of the basic rights generally recognized by law. Of course, as I said, that is the general rule. The general rule in the sense that if you go to section 52, right? If you go to section 52, for example, in the case of like the preference shares, so look, go to 52.1. Read 52.1 for us. 52.1, please. $52.1. Okay, I think we've lost it.
52.1, sorry.
Yes.
52.1.
Yes.
Despite section 34, the right of holders of preferences shares to attend and vote at the general meeting of the company may be suspended on conditions.
Okay, so please, let's pay attention. You see, 34.1 is recognizing a general right of a member to attend general meetings, speak and vote on resolution. But 52 is creating an exception. That is why it says that despite section 34, it is permissible for the company to suspend the right of preference shareholders to attend and vote at general meeting under certain conditions. And what are some of those conditions or some of those circumstances? Well, let's look at section 52.2. Yes, 52.2.
52.2. Despite a provision to the contrary in the constitution of a company, preference shares carry the right to attend general meetings and on a poll at those meetings to at least one vote per share in the following circumstances, but not otherwise. A,
now,
on a resolution
before you go on, I want you to pay attention to the wording of 52.2. 52.2 is trying to say that by reason of being a preference shareholder, you are entitled to not only attend general meetings, but also should it become necessary to have a poll, that is to do direct, rare voting with your shares, then each of your share will carry one vote, and you are entitled to vote in the following circumstances, meaning that the circumstances that we are going to look at from A to D are circumstances in which you cannot be prevented from attending and voting. The only instance where the company could, for example, suspend right? The company may suspend your right to vote. Are those matters not governed by A to D? So those are the things we are going to look at. I've seen that two students have their hands up. Let me see.
Hello, sir.
Yes.
Hello, sir.
Yeah, Francis Pepra.
Yes, by the wording of section 52, suspension of voting right of preferences. What do you mean by preferences? I mean the wording.
Okay, we'll come and discuss shares as a topic very soon, but at this stage, it suffices just to know that we have what we call the ordinary shareholder or equity shareholder on one hand, and then preference shareholder on the other. So preference share simply means that special rights are attached to that share, and the holder of that share enjoys those rights, and non-holders or preference shareholders do not enjoy that right. It may be in respect of either dividends or respect of return of equity, and so on and so forth. So where you are giving preferential treatment, which ordinary shareholders or equity shareholders do not enjoy, then your share is said to be a preference share. And there are various parameters, or there are various situations in which you may be given a preferential treatment over and above equity shareholders, ordinary shareholders. But as I said, we will come and discuss shares as a topic of this home very soon after membership. Okay, so we come back and discuss these matters, but the 52(2)(a) to D is giving us those protected situations in which the preference shareholder is entitled to attend and vote at all costs, and the company cannot suspend his voting right. But outside these instances, the company has the prerogative to suspend the voting right or the right of attendance of the preference shareholder under stated circumstances. So let us keep that in mind. So let's go back to 34, subsection 2. 34(2).
It says, despite subsection 1, a registered constitution of a company may provide that a member is not entitled to attend and vote at a general meeting unless the cost or any other sums of money presently payable by that member in respect of shares in the company have been paid.
Okay, so if you have a registered constitution, that is, if the company has adopted its own constitution, it's permissible for the company to state that if you haven't paid non-paid value in respect of shares issued to you, when you've actually made a call on you, that is when you have demanded payment, we could actually prevent you from attending or voting a general meeting. It is possible for the company to do that once it has its own registered constitution. So let us keep that in mind. So let's look at the register of members, section 35. I want us to finish membership before we close tonight. So let's say we are. Yeah, register of members.
Section 35. Subject to the Central Securities Depository Act 2007 at 733. and any other enactment. A company shall keep in the country a register of members and shall enter in the register, A, in respect of members of the company, the names and addresses of the members, and in the case of a company having shares, a statement of the shares held by each member and of the amount paid or agreed to be considered as paid on the shares of each member and of the amount remaining payable on the shares. 2, the date at which a person was entered in the register as a member. 3, the nature of the interest of each member and the date at which a person ceased to be a member.
Now, before you go on to the B, let me expatiate a little bit. Register of members is, first of all, a document, right? It's a document. And when I say a document here, I'm not referring to only a paper document, because now it can also be what? Electronic. And in fact, if you look at the section 386, section 386, for example, if we go over there, somebody should read that for us, section 386. Section 386. Hello? You don't have your law with you?
So you said section 396?
No, 386.
Okay, 386.
Application of Electronic Transaction Act 2008, Act 772. The Electronic Transaction Act 2008 shall be read as one with section 378 of this act. And where there is a conflict between section 378 and 3772, section 738 of this act shall prevail.
Okay, good. So if you go to section 378, it is headed electronic transactions. And a lot of things have been stated in respect of which you can actually do it electronically. So if you look at like the list of things over there, a whole lot of things. So like the F, keeping and maintenance of a register. Look at the 378F. Despite a provision of this act and any other enactment, the registrar may authorize, just jump to the F, keeping and maintenance of a register, right, to be effected electronically in the manner and through an electronic system approved by the registrar, subject to subsection 5. Good. So if you look at the combined effect of section 378 and 386 of Act 992, you notice that Electronic Transactions Act 2008 at 772 are applicable mutatis mutandis or with necessary modification to company law regime. And in the present discussion, to register of members. So register of members, as I said, is a document, but not just only, if you like, the hard copy document. It can also be electronic. Okay, so let's keep that in mind. So register of members can be just the normal notebooks that we have, or by reason of section 378 and 386 of Act 992, it can also be electronic. So let us keep that in mind. And then we are told that shall keep in the country a register of members. Ordinarily, if you read 35.1, you get the impression that if we are saying that the register should be kept in the country, that is in Ghana, then are you referring to physical documents? Because if it's electronic can also be held online, isn't it? Electronic can be held online, in which case is no longer necessary where it is located. But for purposes of determining jurisdiction and venue, if you go to the Electronic Transactions Act of 2008, we are told even where something is held electronically or where something is sent online, how we can determine the particular place that it was sent from and so on. So for purposes of our law, even if you have electronic register, we will still consider it as being located in what? In Ghana, even if it can be accessed online, because the server on which it is held will be a server more or less in Ghana. So let us keep that in mind. And then we have the various information which is supposed to be stated in the register. That is what has been adumbrated for us. But another point to note is that the register of members is very important in terms of democratic operations of the company. Now, when companies have meeting and they need to take a decision, they take a decision through passage of resolution. And that means that if we have to do polling, it is the number of shares that you have, which will translate into the number of votes, and so on and so forth. And for that matter, at every point in time, if you want to know who are those controlling a lot of votes and so on, you need to go and look at the register of vote of members so that you have a clear picture of who is who as far as the company is concerned. So let us keep that in mind. But apart from that, it is also important to let us know when a person's membership came to an end. Now, not too long ago, we saw the various situations in which membership can be said to have come to an end. So the register of members is only supposed to have that information. But there's a new addition, which was not necessarily in the old law, that is in the repeal at 179. And I want you to pay attention to that. So let's look at the section 35 B, 35 1B. Let's look at the 1B, please. Very important as a new addition to the law, and we discuss its relevance.
35 1B. In respect of each beneficial owner of the company, the full name and any former or other name of the beneficial owner, the date and place of birth, the telephone number, the nationality, national identity number, passport number, or other appropriate identification and proof of identity, residential, postal, and email address, if any, place of work and position held, the nature of the interest, including the details of the legal, financial, security, debenture, or informal arrangement giving rise to the beneficial ownership, and a confirmation as to whether the beneficial owner is a politically exposed person.
Good. So this is very important addition to our law, section 35(1), subsection B. But before I explicate further, we need to understand who a beneficial owner is. And I've told you that The Companies Act, Act 992, has got its own dictionary. That is the interpretation or definition section in the Schedule 1. So let's jump to first schedule and let's look at the meaning of a beneficial owner. So if you go to the first schedule, which is the page 301, beneficial owner is explained over there. A beneficial owner means an individual A, who directly or indirectly ultimately owns or exercises substantial control over a person or company. So if you fall within that category, then you are a beneficial owner. B means an individual who has a substantial economic interest in or receives substantial economic benefits from the company, whether acting alone or together with other persons. So you're also a beneficial owner if you fall within that. C, an individual on whose behalf a transaction is conducted. So if you are someone, you call the shots, then, or if a transaction is conducted on your behalf, you're a beneficial owner. Or D, who exercises significant control or influence over a legal person or legal arrangement through a formal or informal agreement. Yeah, so if we look at the first schedule in trying to define beneficial owner, you notice that 4 things are stated, and each of them is disjunctive. So you have the disjunctive word, like or. You know, between C and D, you have the or, the meaning that in order to determine whether a person is a beneficial owner of a company, you don't need to satisfy all the 4. If only one is satisfied, then you have really made out your point as to whether a person is a beneficial owner or not. Now, you may be wondering, what is all this? Well, the addition of disclosure of beneficial ownership of a company in our law is part of the attempt to fight corruption. It's part of the attempt to check money laundering and so on. Because what happens is that previously, without this provision, I could maybe steal public money or take any dirty money anywhere. I give it to someone either to go and buy shares, okay? To go and buy shares in a particular company. And that person, his name is in the, in the register of members as a holder, but he is not the real beneficiary. The real beneficiary is never disclosed. So if you want to track, and it may so happen that sometimes you may even get someone whose income, monthly income is not even up to 500 Ghana cedis, and you go to a very significant company, and the person is said to be having substantial or significant number of shares of high value. Then you begin to wonder, someone whose monthly income is not even up to 500, how can he have so much shares in a big company like Tele Oil Ghana or any other company that you think of? Now that should tell you that the rare beneficiary, the main person benefiting from those shares, are behind somewhere, and that person's name is not disclosed. And this person is just being used as an alter ego, just as a facade, just as a cover up. And that is why the lawmaker has provided Section 35(1)(b) that you must disclose the information about the rare beneficial owner of the company. And we're also interested in the nationality, because you could get maybe people stealing money from other countries or pushing drugs or some other unacceptable means of accumulating wealth, who will come to Ghana and they will try and buy shares. Or sometimes, we have this law we call the Ghana Investment Promotion Center Act, a legislation which seeks to define which sectors of the economy non-Ghanaians can actually participate and all that. So having full disclosure of who the beneficial owners are in respect of shares held in a company will help us to also check all that. So please look at that. So when you are learning here, you have to go to the first schedule and look up the meaning of who a beneficial owner is. So let's look at 35(2). Yeah, 35(2). Oh, are they sleeping? They're tired there, and I'm going to end the class.
35(2). For
Okay.
the purpose of paragraph B of subsection A, where a member of the company is not...
Yeah, go ahead.
Hello?
Yes, please, go ahead.
Where a member of a company is not a beneficial owner, that member shall A, provide the company with the particulars of the beneficial owner at the time of becoming a member as set out in paragraph B, and B, and update the company with 28 days of a change in a particular submitted under paragraph A. 3, the entry required under subparagraph I and III of paragraph A of subsection 1 shall be made within 28 days of the conclusion of the agreement with the person to become a member. 4, okay.
Yeah, so we are just trying to provide more rules in terms of making it mandatory for you to furnish the information about who the beneficial owner of the shares that registered your name are. So if you acquire shares, you have obligation to disclose whether you are the rare beneficial owner or somebody else is the beneficial owner. So that one is mandatory. And if you don't comply, you cease to be a member. So if you look at subsection 4, where you have ceased, where you have failed to provide evidence, right, which will let the company become convinced as to who is the rare beneficial owner of the shares, which have been allotted to you. If you fail to provide that, then after expiry of 28 days, if you fail to provide the information to the company, you automatically cease to be a member, as it were. Okay, so let's look at subsection 6.
Hello, sir.
Subsection 6.
Yes.
A company
Hello,
shall
sir.
begin. Should I read, please?
Yes, go ahead.
A company, subsection 6. A company shall within 28 days of making an entry.
Make some suggestions.
Yeah, yes.
Sir, please. It's
there.
obvious my people are tired. So I will humbly want to suggest that you end here, then we continue maybe tomorrow or another time.
All right. So
if
all right, so have a good night. I will let you know when if we're able to continue during the week. All right. Okay.
All right.